Child support is modifiable in Nevada. It's dependent largely upon gross earnings, meaning what a person earns before taxes are withheld. Um, in Nevada, child support can be reviewed by a court and subsequently modified if 3 years have elapsed from the last order of support, or a person has increased their gross earnings by 20%, or if they've suffered a loss of 20% of their gross earnings, the court can modify child support downward. So the short answer is that child support is modifiable every 3 years, or if there's been a 20% increase or 20% decrease in gross earnings. To modify a custody agreement or visitation schedule, that can be accomplished one of two ways. One, the parties are able to meet and confer and actually agree on what the new schedule will be, and by so doing, they will prepare a stipulation and order for the judge to sign, and that will become the new binding order of the court. If the parties are incapable of reaching a consensus as to a new schedule, and they begin fighting with one another, in that circumstance, litigation becomes necessary. The procedure to do that is to file a motion to modify custody and ask the court at a hearing to change the schedule based on the facts and circumstances that you present to the court. This can be a tricky thing to do, and I encourage you to seek competent counsel because it's not an easy process. If you're interested in attempting to modify custody of your child or children, it's imperative that you have the appropriate evidence to be able to present that to the court so that they actually rule in your favor. Without significant or substantial evidence to be able to modify custody, generally the courts are reluctant to want to do so. Thus, text messages, emails, co-parenting app communications, grade reports, whatever is fact specific and will help you prove why the court should modify custody in your favor. One thing that I'm asked often is, how do I modify custody if a parent or myself desires to relocate from the state of Nevada and wants to take the child with them? In that circumstance, there is case law in Nevada that dictates what things a person must prove to relocate from the state of Nevada with a minor child. Relocation cases are very difficult cases, and the courts do not take them lightly. Significant evidence is necessary to prove why a relocation should occur, what benefits the child will receive from relocating from the state of Nevada, and the court wants to know how the impact of that relocation will affect a parent who's left behind in the state of Nevada or goes away to a different state without the child. Thus, there's a lot of considerations that must occur, and I'd be delighted to speak with you about them. Feel free to reach out to my office and schedule a consultation so we can discuss those factors and elements, what evidence you have to be able to evaluate your case and whether the success of it will be effective or not.